Hello, and welcome to Of Significance, the podcast about what's relevant, what's important, and what's meaningful. It's where we address whether the numbers and analytics we see daily are incredibly useful or nearly insignificant. I'm your every person host, Brent Buckwright, here with two experienced experts who have been analyzing big data since before it was big. They've signed non-competes to not do another podcast. It's Dr. Nathan Woods and Dr. Steve Bronars. How are you today?
Doing great, Brent.
I'm fantastic. I have not signed anything.
Perfect. Well, the Federal Trade Commission, or FTC, banned the use of non-compete agreements in most circumstances. This was supposed to go to effect in September of this year. With court disputes, though, it's currently in a kind of legal limbo. So no non-competes for you to sign now. As it stands, the proposal would ban all new non-competes and render most existing non-competes unenforceable. The current proposal allows existing non-competes to be applicable to a limited number of senior executive positions. So this is going to be resolved in the future. There are tons of pros and cons of non-competes, but one claim by the FTC is that it will raise incomes for people. And this was based off of a study they conducted. So today, we want to talk about what they did and how confident we can be that the specific claim that this will mean greater incomes for workers is really true. So, Steve, Nathan, my first question for y'all, what is a non-compete agreement and why do businesses and people want to sign them in the first place?
A non-compete is really an agreement between the worker and the employer. The employer is going to present it to the worker that would limit the worker's mobility after they would stop working for the employer in question. So it really puts a restriction on the next job they can take after this one. And it would usually extend for a certain time period. And it would cover certain other employers that you could work for, like the competitors for this firm. And what we'll be talking about today is that there could be a variety of reasons why a company would be interested in getting you to sign the non-compete. Some of the most obvious examples would be that you have some trade secrets or some other information that your current employer would not want you to take with you when you go work for a competitor.
Yeah, and I think from the person that's being asked to sign the non-compete, maybe the answer is you don't want to sign it. But you could be induced to sign it and you might get something in return, like a substantial signing bonus or something that is worth your while. So you're willing to constrain your ability to leave, pursue other opportunities, but you're getting something of value in return.
You get the leads like in Glengarry Glen Ross.
Yes.
Right.
You've got to get those Glengarry leads.
But
That's
and
right.
and I think we're gonna get to this, but if you don't get the leads, if you're induced to sign the thing, but maybe you don't get something very valuable in return, you might at some point feel like you wish you hadn't signed that thing.
Well, so non-competes are different than, say, a non-disclosure agreement or a non-solicit agreement. Those are not things that are covered in this rule, correct?
Well, I think that, and this is not legal advice, this is more of a legal question.
Wait, real quick. That's my line.
Okay.
Just quickly, nobody should be relying on us for legal advice.
Yeah.
What I've seen people, and their summarizing of this rule, it's an FTC rule, is that if the NDA, the non-disclosure agreement, or the non-solicit was written broadly enough, it would still be banned by this because they go, that's basically a non-compete. You've just kind of disguised it as something else. And so, yeah, you could still have non-disclosure agreements and non-solicits, but you'd have to look at the details of the rule to say like exactly how they would have to be specified so that they wouldn't also be banned.
So the FTC comes out with this rule and it bans non-competes based on their review of some economic factors. What exactly did they look at?
Well, they looked at several different things. They talk about how this might affect startups, how it would affect innovation. But I think the area that Nathan and I are most interested in is how it might affect the earnings of workers. And the theory behind it is that, one of the ways in which your income could go up is if you get an outside offer from a firm that competes with the firm that you're working for. And if you cannot accept that, it will have a chilling effect on the number of those offers. And so that's the theory under which one could imagine that if you discourage people from leaving because they've signed the non-competes, you may reduce the amount of movement from one business to another, and maybe reduce the pay of the individuals.
And Steve, that would extend, right, in theory, that would extend not just to the person who would have left had they got that offer, but maybe to everyone that was in that labor market that might be in those kinds of jobs, right?
Right. And I think that is the argument that the researchers have made in the kind of the studies that the FTC was citing. And they're academic researchers, and they kind of approach things a standard way that you would in this context. It's kind of similar to when we were talking about human capital models. And one of the reasons that I think that is assumed is because there are very few data sets that are out there that would indicate whether somebody had signed a non-compete. And, I think there's some really interesting research that J.J. Prescott, who is a friend of Edgeworth Economics, and his associates.
Friend of the pod, probably.
Friend of the pod, yeah. Right. That have done that show that there's probably about 20% of the workforce who has signed a non-compete. And before they did that research, nobody really knew because it's not in the typical and standard data sets. So, one of the interesting things is the study upon which I think the FTC relies pretty heavily in the rule justifying this uses data where we have no information whether you've signed a non-compete or not. You have no idea. And so when they're looking for these wage effects, kind of based on the data they have, it has to be sort of across the board because they can't really isolate individuals who were signed a non-compete and those who didn't. But like you said, Nathan, the theory says, well, if there's a chilling effect on wage offers, that would just kind of spread through to everybody, whether you had signed a non-compete or not.
So we don't know if you signed a non-compete in these studies. So how do they work exactly?
Well, the research that's been done in this area first recognizes that up until this FTC rule, this has been a state law that determines how enforceable a non-compete agreement is. And so one of the interesting things in the studies that Prescott and others have done is that people will sign non-competes even in states like California. There are only a few. California is one of them, where it's not even enforceable. So that tells you that just because you've signed a non-compete doesn't mean it really can be that effective if you're in a state where it's not that enforceable. And so with the legal...
They just do it for the fun there. They're like, oh,
right.
Well, why not sign a contract? I'm already here signing some.
Yeah.
Overzealous employment attorneys.
Yeah, I know this isn't enforceable. I do this for me. That's self-care.
So the legal researchers have, because not all state laws regulate non-competes in the same way. Some are more allowing enforcement and others are less. And so things that could vary across states are how long can the non-compete last? Is it for a year? No more than a year, no more than 18 months, no more than 6 months. It could be how narrowly defined does it need to be in terms of who you would work for? Because, and you're not going to have a non-compete that would be enforceable in most states where you can't work anywhere. It's going to have to be limited to some competing businesses for the one that you're working for. And so that varies across states. And so what these legal researchers have done, on like a 0 to 1 scale, where 0 is there's no enforcement and 1 is maximum enforcement, each state in each year would get a score. And then either because the law changed or case law, you kind of could move on that scale. And so a key feature of these studies is what happened to the enforceability of non-competes between last year and this year in the state that you're in. Did it get harder
the
or
action,
easier?
the action that you're picking up is either between arguably comparable states, given whatever else is in the model, one with, a severe enforcement ratio, whatever that measure is, 0 to 1, and one with a 0, or within the same state from the year before the policy went into effect to the year after.
Yes, they're
Is that
both
kind of the idea?
they're both types of studies. One that looks across states at a point in time, and others that says what happened to incomes in this state in the year in which they made non-competes harder to enforce. And what you see in these studies is basically this kind of correlation that in a state that has made it harder to enforce non-competes, that's associated with a slightly higher increase in pay, but obviously that's limited to the kind of changes that you would see from one year to the next in the state itself.
To me, that seems like a somewhat reasonable approach. You try and look at the various state economies, how much people are getting paid. You control for how enforceable their non-compete agreements are and the economic conditions of that state, so that if a state has particularly high growth over a year, you're not attributing that all just to the non-competes, right? What's lacking here? What does this miss?
Well, I think that we could go back to discussions that we've had before about anytime you do this study that I think they give the highest weight to in terms of why they think, and when I'm saying why the FTC thinks that this would cause incomes to go up. The study that they rely on uses what's known as the current population survey, which is a survey that's done every month, and they use 25 years of data, but they don't use anything like in the last 10 years or so in the current population survey. I'm not sure exactly why they didn't have more recent data in there. And
that's because the CPS's new stuff is just not as good.
Good.
You want to go to the CPS hits.
Yeah. So it's a lot of years that it's looking at, but really there's not that much information that we know about the individuals that might determine why somebody would earn more or less. We know what industry they're in. We know what occupation they're in at kind of a broad level, but they're going to be working for different companies. Some of the companies, pay more than others. And then the other thing that, we don't know even from the current population survey is how long have you been working for your employer, what we would call like your job tenure. We don't even know how much experience you have. We know how old you are, and we can kind of back out how long we think you probably could have been working. But people can be shifting from one career path to another. They can take time off. And so the ability to explain differences in pay across individuals or between states or anything like that in something like the current population survey is pretty limited. It's not like the data that we would use to do pay studies.
Firm level data, right? We don't have the firm level data. It's across firms, industries, jobs. Everything's all kind of lumped together.
Yes, it goes across all the different jobs, and then you might know that you're in the finance industry or the insurance industry or the tech industry, and you know the occupation. But we know that not all jobs are created equal, and some of them are going to pay more than others. And then, somebody's been in the same job for 10 years, other for 1 year.
For sure, the tech industry must be the same as it was 10 years ago or 20 years ago.
Those guys never change.
That's right.
It's just like the same thing every day.
So, I think another thing that pops out of a study like this is if you have enough information, which they have, millions of observations because they got like 25 years of monthly data from the CPS, they're able to identify about a little bit less than a 1% change. This change, for the typical change that you would observe in a in a state's enforcement regulation of the non-compete, whatever units that's in, which is on this index that goes from 0 to 1, but whatever the typical change is, that typical delta, it seems to be associated with about a 0.9% increase in pay in that state. And that is the estimate that the FTC uses for what they think will happen if everywhere in the US non-competes are banned like they are right now in only a handful of states.
So is it possible that that 1% is too small because it currently accounts for the signing bonus you get when you get the non-compete agreement in the first place, such that when you move to another job, you're not getting the bonus that's associated with it anymore, and your total compensation over a period is lower?
Well, I mean, I think this goes along exactly with what Steve's saying in terms of the information that's in there. You don't know exactly from the survey who's signed a non-compete, and I don't think there's going to be any way to know in the survey who is saying when they report what their wages or salary or income is, whether that includes or does not include whatever that signing bonus might have been. I'm hoping for somebody who signed one of these things that's more than 1%, though.
Yes. I mean, I think that's a very good question, Brent, that there are a lot of things going on here. One is that we don't know how people are getting paid. We don't know how much of the pay is due to a signing bonus and how much is due to their regular salaries or commissions or other ways and that we're getting paid. We will have some measure of what their labor earnings are. And so, when we think about what the theory is saying, what could happen, I think there's a group of people who would have negotiated for the non-compete. And nobody, like Nathan said, nobody really says, hey, I want to sign a non-compete. They say, I'm willing to do it, but what am I going to get in return? And so I think for the higher level executives and people that are actively negotiating for it, presumably they got a bonus or some upfront payment in return for their willingness to limit their future mobility. And so even with this 1%, let's say, or 0.9%, it's not clear that was occurring across the board. Like that's an average, right? And we know that could be 1 out of 10 people got an extra 9%, and the other zeros, the other 90% of the people got 0, and that averages out to 0.9%. So I think, that's what you're getting when you're running these regressions is like a comparison of the averages before and after the change at the state level.
So is there a right way to do this? And kind of what will we need to be confident that imposing this rule would have the proposed benefit on people's incomes?
Well, I think that...
Sorry, I didn't mean to stun you with the question. Do you want me to ask it again?
No, there is no right way to do this.
There's no right, but no. I think that I don't want to make it seem like the only thing, I mean, it's a very long, involved paper that the FTC cites, and they tried a bunch of different things, including allowing the effect to be different for more highly educated workers or workers in the tech sector, workers, right? And what you tend to see is that it's not the same thing across the board. But if you were going to try to give one number, that would be the number is like 0.9%. And that's the one that the FTC kind of mentions. But I think that it would probably be better if you're proposing making a big change, like allowing, in a lot of states, you allow non-competes, and now they're going to be banned. It's going to override the state law and ban it. I think it would probably be better to find examples of where states did that as like a laboratory experiment and said, hey, what happened when we did this? And then other states might try to imitate it, or the FTC might say, hey, that seems like a good idea. Let's just make a rule. But I think that would be there aren't a lot of states over this 25-year period. I don't think there are any, in fact, that actually went from, hey, we have non-competes that are pretty enforceable to like, nope, they're going to be banned before and after. I think the other thing is that these changes occurred all at a bunch of different times. So it's hard to disentangle the effect of the non-compete change in the regulation in your state with like the Great Recession or the dot-com bust or other stuff that happened in between the 1980s and 2015 or whenever this study covered. So there are a lot of different things that can change over time. And Brent, you were pointing out that one of the things that you try to control for, but I think that it's a little bit of a leap to say we're going to look at this study and really have a lot of confidence that we've isolated the impact of the policy change.
Yeah, no, right. And not to knock the study and the rule too much. I think the, kind of banning outright, and I, as I understand it, the current version is maybe not banning everything outright, and senior level executives would be exempted, and maybe some others as well. But I mean, I think common sense and practical kind of intuition would tell you that some of the really egregious examples that would show up in the media over the last 5 or 10 years of, hourly workers making sandwiches, signing these things, maybe that doesn't make a lot of sense. Really senior level executives that have access to, exclusive proprietary types of information, have benefited from tremendous investments that their firms have made in them, are kind of at the other end of the distribution, and maybe the rule could be different for them. And then I think kind of in the middle somewhere is, people that might be, in the middle of their career, they're somewhat benefiting from the investments that their firms have made in them, but maybe are not receiving the gigantic signing bonuses or whatever the other consideration is that they should be getting for having signed away their mobility rights. So I think it's tough to make a rule that sort of, categorizes all the different kinds of workers in the different industries, different points in their experience profiles, and does so in a reasonable way.
Yeah, and I think that to follow up on that, one of the first questions that you asked, Brent, was like, why might a company do this? And I do think that the studies by J.J. Prescott and others show that it's more common to have a non-compete if you're in certain industries and more educated. But it can happen for some of the workers that Nathan was talking about. And some of them seem like, well, I'm not sure what the point of that is. But one of the concepts in human capital investment is that the business is less interested in investing in your skills that are general and portable and you can take with you, because they only get a return on the investment if you stay with the company. And so it's possible, but this is going to only be for some of the people that would be subject to a non-compete, that the reason why I'm trying to limit your mobility is because I've spent time investing in you so that you acquire the skills to do the job that you didn't have when I hired you. And it's a losing proposition for me to pay all those investment costs, many of which are hard to kind of measure because you're, wasting other people's time as they're explaining stuff to you and all the things that you do, Brent, to help people that haven't figured out how to do the job yet. And the idea that you would then take that investment to go work for a competing, consulting firm, tech firm, or whatever, would have a chilling effect on companies' willingness to offer that kind of training. So that's an argument that one could make for why, rather than just a lump sum signing bonus, why someone might be willing to consider a non-compete, because they go, if I sign this non-compete, then you'll invest in me, and then my income will go up over time because of that. And if we couldn't have that non-compete, maybe those investments wouldn't be made. That's a theoretical possibility for, we talked about the pros and cons of the non-competes.
Right. So the big takeaway here is that maybe there is a compelling interest in the government banning these, that there might be some value to workers because in certain circumstances, there's no reason for one company to restrict the movement of their employees in the future. But we probably need really good reasons for banning them in the first place, and we need good evidence to justify it.
Yeah, you had me at government banning. I'm on board. I don't know about Steve.
Yeah, well,
he might not like linking those two words together.
Yeah.
I think the challenge is how do you figure out who this is going to work for to protect the employees that need the protection versus protecting people that don't need that protection and are negotiating a pretty good deal on their own.
Well, I've got lots of reactions to that, but I'll try to limit it to just a few things here. Number one, I do think if the concern is, because I do think there are a lot of people out there that aren't paying attention to what they're signing when they take a job and don't realize that at the time that they're accepting the job that they're subject to a non-compete. So there could be some regulation that you have to be upfront about that and disclose that. And that would still allow the people that want to negotiate for it to see if there are some benefits from it, but you wouldn't be fooling people into taking a job that they didn't know had this non-compete. But I think the other things are, right now it's handled by the states. And so we have some states, Florida, they're allow more aggressive enforcement of non-competes. California's on the other end. And so there is this...
laboratories of democracy.
Yeah. So there's that. And then the other thing is, if the federal government wants to do something, and this relates to Chevron deference, and do we have the administrative state through the FTC come up with this rule, or do we have Congress pass a law? And I think that the issue when it's a rule like this is that a new administration could come in and go, hey, we changed our mind on that. Let's allow non-competes again. And I mean, obviously Congress could change their mind too, but I think that's a question as well.
We can all look forward to Mr. Smith at some point coming back to Washington, and we could pass that law. That'd be fantastic.
But we will force him to sign a non-compete agreement. Well, that's been this episode of Significance. This episode's been brought to you by Edgeworth Economics, a leader in economic consulting, and with the help of our producers, Kimberly Krewald, Ryan Deal, and Brian McLamara of Brand Ready Media, with music by Armwell Lang. Thanks for listening, StatPack, and always remember to check your assumptions.